More importantly for you all, I participated in the We the People program. I was also in Unit 5. So I know you all are nervous, but take a deep breath, and I know you will do a great job.
Good morning, Virginia. My name is Gus Chin. I'm a municipal judge from Utah.
Good morning. My name is Matt Gutwein, and I am retired, but I previously taught constitutional litigation and civil rights at the Indiana University Maurer School of Law. And Senator Flores was being modest. Her team won the national finals when she participated in We the People, but very eager to listen to all of you and have this conversation this morning.
Good morning. My name is Chloe Wright.
Good morning. My name is Maya Mahigan.
Good morning. My name is Ella Purificacion.
Morning. My name is Isabel Jensen.
Good morning. My name is Kelly Coughlin.
Great. Okay. Thank you all this morning. This morning we are doing question 2. A Bill of Rights is what the people are entitled to against every government on earth, general or particular, and what no just government should refuse or rest on interference. Do you agree or disagree with Thomas Jefferson? What are the advantages and disadvantages of a National Bill of Rights as compared to State Bill of Rights? What are the differences between positive and negative rights? And which are more important to the preservation of liberty? You may begin.
During the Constitutional Convention, the founders made what now seems to be an egregious omission. They failed to include a Bill of Rights in the initial draft of the Constitution, an exclusion that would become a rallying cry for anti-federalists across the 13 states. After intense debate, the framers agreed that ratification wouldn't be possible without concrete restrictions on the new, more powerful government. The purpose of the Bill of Rights is to guarantee protection for the rights of all citizens. However, it wasn't until 1925, with Gitlow v. New York, that the court started to apply liberties guaranteed at the federal level to the states. We agree with Jefferson, even more so through the idea of incorporation, because according to Justice James Wilson, without law, liberty loses its nature and its name. The Bill of Rights provides an explicit framework for protecting the rights of all citizens and enforcing the democratic ideals highlighted in the Constitution.
Since Gitlow, we've seen the gradual incorporation of nearly every one of the first 10 amendments. Nowadays, the National Bill of Rights provides a floor for citizens' rights and ensures that basic minimums are met for all liberties guaranteed by the Constitution, regardless of where people live. Take the 2010 case, McDonald v. City of Chicago, where the court applied the Heller interpretation to the states. As a result of this decision, many states with strict gun laws, such as New York and New Jersey, were forced to re-examine their restrictions. We can also look at cases like Brandenburg v. Ohio, where the court ruled that speech is constitutional unless it promotes, quote, imminent lawless action, end quote, and West Virginia School Board of Education v. Barnett, where the court found that mandatory saluting of the flag in schools violated religious rights, as examples of time when the Supreme Court has established a bare minimum for rights. In both of these cases, the court determined that states or localities were depriving citizens of their First Amendment liberties, thus demonstrating the need for a standard national Bill of Rights.
However, a significant disadvantage of the National Bill of Rights is that a National Bill of Rights cannot defend specific rights or liberties that Americans in different regions believe should be protected. Under the Supremacy Clause and the 14th Amendment's doctrine of incorporation, the National Bill of Rights will always take precedence, and states cannot take away more rights than what the National Bill of Rights protects. But state bills of rights do have flexibility in expanding on rights that are specific to their inhabitants. For instance, Louisiana has more protections for the right to bear arms due to this region's desire to broaden the Second Amendment.
States have also expanded other rights. In 1980, the Supreme Court found that the First Amendment did not give people the right to solicit petition signatures at a mall without permission in Pruneyard Shopping Center v. Robbins. However, Minnesota's Supreme Court granted inhabitants the right to petition without a mall owner's permission in the court case Minnesota v. Wickland. With this constitutional provision, Minnesota allowed more expressive freedoms to be protected than the general protections outlined in the First Amendment.
Considering the first 10 amendments, one of the most striking aspects is the framers' emphasis on negative rights. Other democracies often specify positive rights in their founding documents. Take the South African Constitution, which assures that, quote, everyone has the right to a basic education, end quote, or Latvia's constitution, which guarantees, quote, a basic level of medical assistance for everyone, end quote. While positive rights place more responsibility on a government to provide for its people, negative rights ensure that liberties can't be taken away. Our Bill of Rights was framed to limit the federal government, inspired by the monarchy's repeated infringement prior to the Revolution. Positive rights like the right to marry or receive a public education are entrusted to the state's 10th Amendment. The effectiveness of prioritizing negative rights at the national level is evident in both the continuous expansion and stringent protection of fundamental American liberties, such as the right to bear arms or the freedom of expression. The Bill of Rights ensures that these American rights, essential to the nation's bedrock, will remain steadfast, even as representatives, administrations, and the political climate all keep shifting.
Thank you very much. You all did a great job of listing several of all the rights that are included in the Bill of Rights and how important they are to our nation. So are there times or limits when government can place limits on those rights on the Bill of Rights? And if so, when and how and what type of limits are allowed?
I think one example of this would be, basically a decade after we had the Bill of Rights and the Constitution ratified, we had the Adams administration with the Alien and Sedition Acts, and they basically threw people in jail for speaking out against the national government. So, and in times of national security, or when there are threats to national security, such as wars or international crises where America needs to present a unified front on the international stage, that is a time when the federal government can limit things like the First Amendment, for example.
And any other time? Go ahead.
Sorry, let me toss a question at you. You mentioned a number of Supreme Court cases. Has the Supreme Court always gotten it right in its interpretation of the Bill of Rights and its application?
No, because we've seen court cases overturned and we've seen jurisprudence change over time. And I think, again, we can look to the First Amendment. So we had Minersville v. Gabaitis in the 40s, which found that students did have to salute the flag, or that schools could implement mandatory flag salutes. And the court said, oh yeah, that's totally constitutional. And then, just a few years later, we had it overturned with West Virginia v. Barnett, where the court actually said, no, actually, never mind. You can't force students to salute the flag. That violates the free exercise clause. So that was one time when the court overturned its own decision.
And another example of this would be with the RFRA case laws, because the court kind of decided that religious freedoms would be kind of neutralized in the sense of other rights. It wouldn't be like as prominent as it is we see it today. And RFRA, which overruled it by legislation, guaranteed that religious rights were more prominent and protected.
Thank you.
So the Supreme Court has often recognized individual rights and liberties that are not found expressly in the language of the Constitution. For example, the Obergefell decision, where the Supreme Court recognized the right of same-sex couples to marry. That right is not found in the language of the Constitution. When is it appropriate for the court to recognize new rights not in the language of the Constitution? And what is the court's analysis in deciding whether to do that or not?
I think that can happen simply with changing times. Like in Obergefell v. Hodges, we saw this increasing need in the people speaking out for gay marriage rights in the court. So when the people bring up the need for these rights, that's when it's appropriate for the courts to reassess and make decisions.
It also happens in cases like Roe v. Wade. We see a lot of this with incorporation cases. And so with abortion, we've seen how abortion laws and the right to abortion has been protected nationally.
We also see rights being started up in the states, like the right to smoke marijuana or grow marijuana. Like it starts in the states, it develops, more states agree with this rights, even if it's not legalized nationally. As more states legalize it, more likely the nation is too.
Tying back to Maya's point, with changes we see over time, I think this also applies to privacy. You know, with Louis Brandeis was kind of the first justice to talk about a reasonable expectation of privacy, and prior to him, it was really just privacy in the home. Whereas sort of through the Brandeis era, we saw a change to where the government started to not be able to like wiretap you without a warrant and things like that. So as technology has increased, we've also seen an expansion of an increase to privacy, of a right to privacy as we've needed it.
But changes over time, is that the sole standard? For example, there's a generally recognized that there should be gender equality, but the Supreme Court has never recognized a pure right of gender equality. Changes over time, we've recognized there ought to be a right, people ought to have health care, but there's never been a constitutional right to health care. You know, I think we can go on and on about changes over time, but it's got to be something more than just changes over time, right? Because there's lots of rights that people, you know, a right to have a preserved climate, but there's no constitutional right to that.
I think you can look to the idea of positive rights versus negative rights for this question. Our Constitution, especially the Bill of Rights, is a negative rights focused Bill of Rights, like is protected rights. And what you were listing are a lot of positive rights, like the right to healthcare, the right to a good climate, everything like that is kind of rights that are not protected by the government, therefore not necessarily needed to be written in the Constitution at this point in time. Whether we want to protect those later as a community, we could rally for that, but right now those aren't protected rights.
We would also maybe look more to legislatures to protect those rights. So, you know, we saw with RFRA where the court ruled for a neutral interpretation of the First Amendment, and then the court came in and said, actually, no, we are allowed to create religious exemptions. So it's mostly in the past been the job of Congress to sort of show positive rights and enforce positive rights among the people, as well as the job of the states and their state legislatures with those police powers.
Yeah, I think it's really important for the states to that's up to the states, because each region has different set of people that they the government is governing. So I think it's important to listen to those small amount of people instead of kind of having a federal at a federal level defending those rights.
But going off of Chloe's point, there have been times when the legislature has failed to address these positive rights, such as No Child Left Behind, which was seen by many as a failed attempt of addressing the right to education. So it would be helpful at some point when if the Supreme Court could step in and address these positive rights, or we could add that to the Bill of Rights.
And I think one big positive right that we would see would really help out would be an addition of a positive right to vote to the Constitution. And that would sort of end this cat and mouse game that we've seen through the years of states just testing how far they can sort of limit this right to vote, this negative right to vote. So we've seen it with Georgia's voting laws most recently, and it always gets thrown to the court. But if we just added a positive right to vote to the Constitution, then it would really end the state's ability to continue just trying to stretch how far they can limit that right.
Okay, so just real quick here to wrap up, are there any circumstances that should cause someone to completely lose a right that's listed in the Bill of Rights?
Well, I think we could see this after 9/11 with the privacy being lost almost. That's loosely interpreted through the 9th Amendment. And I think that people can lose their rights during a time of national security or crisis, such as after 9/11, and the addition of the Patriot Acts and other acts that barred security and privacy.
And that is time. Congratulations to Virginia. Very well done, Unit 5 team, and congratulations to your teacher coaches. I just want to turn it over now to the judges so they can give their feedback, but you should feel very proud of yourself. You can all breathe and relax now.
Indeed, you all should be very, very proud of yourselves. You had an excellent prepared statement with well thought out reasons. You kept coming back to case law, not just in the prepared statements, that's to be expected, but in your follow-ups. You all did a great job of citing constitutional cases, citing historical references, going to things that are very, very recent, that are in the news now. And you were able to bring together older references, newer references, again, court cases, the role of the state legislature. I think that you all did a really great job.
I agree with the senator. You did a lovely job in your opening remarks. I, for one, appreciate the authorities you addressed during your responses particularly. I'm pleased with the thought that you've given in your responses to our follow-up questions. It demonstrates that you're thinking current and into the future. And I would hope that as you explore some of these positive and negative rights that you'd like to see for our future, that you will play a role with the civic understanding and knowledge that you have in making sure these are enshrined in a document that will make it more permanent so that the future looks a lot brighter. Well done. Thank you.
Well, I agree with my colleagues. Right out of the gate, you hit us hard with our founders engaged in an egregious omission, which I love that phrase. And I love it encapsulated so much in just those two words, an egregious omission. And then you took off from there, talking about the evolution of our individual rights, the Doctrine of Incorporation, the First Amendment, the Second Amendment. I loved your references to Latvia and South Africa and their more expansive constitutions with positive rights. And then your answers to our questions, starting out with the Alien Sedition Acts, right, which would be unrecognizable to our times. That was very normal for them there, but it shows it was a very powerful example of the evolution and growth of what we recognize to be as constitutional rights, because we would never permit the Alien Sedition Acts today. I loved your references to RFRA overturning Smith, the Minorville decision, and then this very sophisticated, nuanced grappling with, is it appropriate sometimes the courts respond to the progress of our community? Sometimes it's state legislators that do that, and we leave it to those legislators. Sometimes it's the federal government, as in RFRA, to do it. So very sophisticated knowledge, and then recognizing privacy rights under national security, 9/11. So really thoughtful, evidence-based, sweeping presentation. So warmest congratulations. Really wonderful job, Virginia.